The talk will be stereotypes and body language in courtrooms when misconceptions distort the justice. So today's talk will be divided in 7 parts. In the first part, I'll address historical methods for determining the truth, and this will bring us to the Supreme Court of Canada, the position of the highest court of the country on demeanor. Then I'll address the dangers of misconceptions, and also I'll raise issues or criticisms about nonverbal communication in the justice system, and also I'll answer some of those criticisms. Then, following this part, I'll address the science of nonverbal communication and the issue of virtual trials, which is, because of the pandemic, an extremely important issue, and then we'll conclude the presentation. It will last around 1 hour. So, courts today, when the judges listen to witnesses, and sometimes there are different versions of the same event, judge have to determine who is lying and who's telling the truth. And sometimes both witnesses are telling the truth from different perspectives. But what the judges have to do today, which is establish the fact and then apply the law, is something that is done for many, many years. And throughout history, there were ways to determine the truth. The oldest document that I have found for the past years studying this issue is from a very old spiritual text. This is the translation from 1845, but this text dates back 3,000 years ago. And in this text, there were instructions, and you see it on your screen, there were instructions, okay, on how to find someone who was trying to poison you. And in those instructions, there were mentions of nonverbal communication. So this is the oldest text that I have. There are sure other texts, but this is the one I found where nonverbal communication was an essential part of how to find someone who was about to commit a crime or was committing a crime. So how you found the poisoner is because, for example, the poisoner was rubbing his great toe along the ground, or shiver, or his face discolored. There was not the mention of, well, you have to look at nonverbal behavior, but there was those cues, those nonverbal cues that were suggested to find someone who was committing a crime. The use of nonverbal cues or nonverbal observation, well, all throughout history, there are other examples. If you look, for example, at trials by ordeals, or the story of King Solomon. You know the story of King Solomon. There was 2 women who were claiming that a child was theirs. And King Solomon says, well, if both of you say that you are the mother, then I will cut the child in half, and I will give both to both of you a part of the child. And then one mother says, no, just give the child to the other one. And how she showed empathy, compassion, was the reason why King Solomon decided to give this woman the child, because only a mother could have such a reaction. And there are also trials by ordeals in the Middle Ages. These were physical tests that were based on spiritual ideas, the ideas that a higher power would not make someone innocent suffer. So, for example, you had the red iron ordeal, where someone had to put a piece of metal, a piece of iron, red, so very, very hot, in the end. And there was an old ceremony. I'm just taking a short resume of that, but essentially, the piece of red iron was in the end, and then afterwards, people were to look in the end, and depending on how it had how do we say that? In French, we would say, how the scars appeared. Depending on how the scars appeared, well, this was used to determine if someone had committed a crime or not. It was not nonverbal communication, but it was observation. And the use of nonverbal observation or nonverbal behavior, well, you have other examples throughout history during the use of torture, or even, and we come back more of with today's talk, where there was cross-examinations that were developed. Actually, cross-examinations was called beyond any doubt the greatest legal engine ever invented for the discovery of truth. But by the way, just to make a short parenthesis, today's research questions the use of cross-examination to get to the truth, but that's a whole other story. But so all throughout history, there are ways to detect who committed a crime or not. And in those ways of detecting the crime or the guilt, there is this use of nonverbal behavior. Also, throughout history and still relevant today, there's the polygraph that is used. It's not the observation, so to speak, of a person's behavior, but it's the measure of things that don't speak. So these are nonverbal elements. And by the way, there is, as many of you know, controversy around the polygraph, but the reason why in Canada polygraph is not admissible in evidence is not because of the scientific controversy. It is because the way polygraph is used, and if polygraphists come to testify in a criminal trial, and that's just very specific issues, and I'm talking about criminal trials, the reason why the results are not admissible in evidence, the result, not the declaration that are made during the test, but why the results are not admissible in evidence in Canada in criminal trial is not because of scientific controversy. It is because, as the Supreme Court says, the polygraph evidence amounts to credibility assessment. And it is a basic tenet of the legal system in Canada that judges and jury are capable of assessing the credibility and the reliability of evidence. So again, you go way back in time and you see that nonverbal behavior, nonverbal observation is really a part of how you determine if someone committed a crime or not, if someone is guilty or not, if someone is credible or not. And up to today, it's still the same. If you look at the Supreme Court of Canada's position on demeanor, well, let's just go back to the basic. Credibility, and by the way, credibility is not a synonym of veracity. So these are two different things. But credibility, as the Supreme Court says, it pervades most trial, and at its broadest may amount to decision of guilt or innocence. So really, credibility it pervades most trials. So it's really there. And I would argue that even if there's no witnesses, there are issues of credibility. Credibility of the lawyers, for example, it plays a part in their capacity of persuading judges. And by the way, I mostly refer to judges because here in Canada, most of the trials are bench trials. So trials where there's only a judge, there's no juror. So credibility, according to the Supreme Court of Canada, is everywhere. Make it short. And the judges who assess credibility, well, they can use demeanor. The Supreme Court says it explicitly, and appellate court, and there is really no discussion about the fact that it's a position of the Supreme Court of Canada. I'm not saying that there are questions about this. There are questions about this position, but the position of the Supreme Court, the highest court of the country in Canada, is that the judge or jury has the opportunity to observe the demeanor to hear the testimony, so not only to see, but to hear the testimony and to assess the evidence presented. And when it comes to the observation of demeanor, these are what I'm showing you. These are just a few examples, by the way. There are many more. But the Supreme Court even goes further than that. The Supreme Court of Canada, again, the position is that the lower court judge can hear the evidence and watch the demeanor of all who testify. And this is considered an advantage. And the trial judge can even, and there are, look, here are a few examples of things that, according to the Supreme Court of Canada, trial judge can use. They can take into account the significant pause in the response, the change in facial expression, the look of anger, confusion, and concern. So really, credibility is everywhere. Judges can use demeanor, and these are some of the things that judges can look for. Again, that's the position. And we will come back to some scientific criticism after that. And in 2012, and again, these are just a few examples, but in 2012, the Supreme Court of Canada described two ways, more specifically on how nonverbal communication can be used. So often in court judgment, you will read that nonverbal communication is useful for what? To assess credibility. But in 2012, the Supreme Court of Canada also added explicitly, as I think never before, the fact that nonverbal communication can also provide cross-examiner with valuable insight that may uncover uncertainty or even deception, or assist the lawyers in getting at the truth. And again, in that judgment, the Supreme Court of Canada mentions that, well, covering the witness's face may also impede credibility assessment done by the trier of fact, be it a judge or a jury. Now, if there is this issue of credibility where demeanor can be used, including specific behavior, how do judges, according to the Supreme Court of Canada, will assess those elements? Well, the Supreme Court of Canada says it quite explicitly. Credibility must always be the product of the judge or jury's view of the diverse ingredients it has perceived at trial, combined with what? And that's the main point, with experience, logic, and intuitive sense. So this, when you consider the literature on deception detection and nonverbal communication, of course, this raises question. We'll go back to that in a moment. So not only judges can use their common sense, but what is important, according to the Supreme Court of Canada, is that those experiences that the judges use, well, they cannot be based on inappropriate stereotypes, and they cannot prevent a fair and just determination based on the facts and evidence. This is extremely reasonable, of course. Stereotypes should not be used in courtrooms. However, as we will see, they are used. And unfortunately, the examples that I will show you are what I have argued in the past, just the tip of the iceberg. And so judges should not use stereotypes, but the Supreme Court of Canada also gives more calls for caution, which is in theory a good thing. So for example, the Supreme Court of Canada will say that, well, the judges, there are many characteristics that they need to take into consideration. For example, the general integrity and intelligence of the witness, his power to observe, his capacity to remember, his accuracy in statements. It is also important to determine whether he is honestly endeavoring to tell the truth, whether he is sincere, frank, or whether he is biased. Oh, there's a typo there. Reticent or evasive. And all these questions, according to the Supreme Court of Canada, and all these questions and other may be answered by the observation of the witness's general conduct and demeanor in determining the question of credibility. I'll just say it right now. Calls for caution is a good thing. However, the most important question is, Do the judges have did they learn about those issues? And can those call for caution be really applied? And be really applied by looking at someone? I'm not so sure about that. And it's not a matter of good faith or bad faith. Let me make it very, very clear. Another example of call for caution: every person giving testimony in court, whatever his age, or is an individual whose credibility evidence must be assessed by reference to criteria appropriate to mental development, understanding, and ability to communicate. Are the judge or jurors have learned about those issues? Can the decision maker really evaluate the mental development, understanding, and ability to communicate? And credibility assessment is not simple. Okay, so I'll make it very, it's not a simple issue. It really is not a simple issue. But the problem is that, well, expert cannot testify on that. Again, it goes back to what I mentioned about polygraph. The credibility or truthfulness of a particular witness is for the trial of fact, and it is not the proper subject of expert opinion. That's the position of the Supreme Court of Canada. And it's very clear. Credibility, according to the highest court of the country, is a matter within the competence of lay people. And ordinary people draw a conclusion about whether someone is lying or telling the truth on a daily basis. Well, this position of the Supreme Court of Canada raises question from a scientific point of view when, again, you look at the deception literature. And not only is credibility difficult, and not only judges don't necessarily have trainings on the issue of credibility, expert cannot testify. And then, most importantly, appellate court they will not come back to credibility issues unless there is a big problem. And as the Supreme Court says, appellate court should show great deference to the finding of credibility made at trial and the importance of taking into consideration the special position of the trial of fact in judging credibility, and of having the advantage of the trial judge denied to the appellate court of direct observing the testimonies of witness. So there's really this idea that nonverbal communication is extremely important, not only when trial judge assess credibility, but also because of that, appellate court will most of the time not address credibility issues made by the trial judge. So this raises question about nonverbal communication, credibility assessment in courtrooms, and let's continue on this one. So nonverbal communication can be used, but when it is used, how is it used? And I've addressed that in a few papers. These are two of them. And I'll give you a few examples when lower court judges, trial judges, used nonverbal communication. Let me give you, I think I bring you six examples. Yeah. So here's this 2019 judgment. As the witness gave his evidence, I observed him cough, fidget, scratch his neck, and at times appear quite nervous. Well, coughing, fidgeting, and scratching are what are they sign? What do they tell us? Well, one thing that they don't tell us is that someone is lying. So using such demeanor, such behavior to assess credibility raises this question, because these are gestures, these are misconceptions about nonverbal behavior. Another example, Assessing body language and making eye contact can be of great assistance in deciding whether or not to accept a guilty plea, as well as waiting and making determinations about sentencing submissions. Well, if you have attended the other presentation that I made a few weeks ago, as I mentioned, there is no nonverbal behavior that are directly associated with remorses. So this needs to be taken into account by the court. However, here body language is a determining factor. Noting in the evidence in the pre-sentence report or even in the nonverbal language of the accused, both at the trial stage and during sentencing representation, suggests any concern whatsoever on the part of the defendant toward the victim in the view of the tragedy she experienced. It comes back to the issue of supposedly the fact that there would be a gesture or a behavior that is associated with remorses. Well, truth is that someone can show tears and not be remorseful, and someone can be a poker face, so to speak, and really experience remorse, because people will experience those emotions differently. But the way it is used by courts suggests that courts have another opinion that is different from what the scientific literature tells us. Another example, here it is the body language again. Here it appears that the way the defenders testify is such that his version cannot be believed. His body language, as well as his confused explanation, have in some respect cast doubt on his sincerity. So again, body language is an element that plays a role in determining if someone is sincere or not, when in fact research has shown that there is no such cues as Pinocchio's nose. Two last examples. Here is the opposite. Because two witnesses looked at in the eyes of the decision maker concluded that the testimony were credible. So misconceptions about nonverbal behavior can be used, yes, to conclude that someone is not honest. And sometimes those misconceptions are also used to conclude that someone is honest. But they are still misconceptions. And this is one of the most striking examples that I've seen in the past few years. Having carefully observed the accused during his testimony and noted his great nervousness, his fleeting glare, and his numerous hesitation and cross-examination, the court is convinced that this defendant has simply forged his version of the facts according to the evidence disclosed, and that he thereby lied to the court in a shameless manner. But nervosity, fleeting glare, and hesitations are not signs of deception. Someone can be nervous, someone can look away, and someone can hesitate, and the person is telling the truth. So these are a few examples of how nonverbal and behavioral cues are used in practice by courts. And these are, as I'm about to say, it's just the tip of the iceberg. Because depending on the court jurisdiction, even if the judge consciously observed nonverbal cues, they are not required to mention them in their decision. And that's important because nonverbal behavior, the assessment of nonverbal behavior mostly happen outside of conscious awareness. So if judges have erroneous beliefs about nonverbal cues, it can influence their decision-making process without even knowing about it, about the influence of those misconceptions. But if they see it, so that nonverbal cues is used mostly outside of conscious awareness. But if the judges see something, even if they see something, they are not necessarily required to mention it in the decision. So this is why I talk about the tip of the iceberg. And most importantly, is the fact that if judges use misconceptions about nonverbal behavior, since appellate court rarely come back on issues of credibility. There is a real possibility that if judges read manuals or attend seminars that promote unfounded or discredited claims, well, they might use those misconceptions all in good faith. Again, it's not a matter of good. They might use it all in good faith throughout their career without ever being told that, in fact, what they have learned in such manual or seminar is actually unproven and amounts to nothing more than junk science. So this is a real issue. And I would add that research shows that even if someone holds misconceptions about a subject and you present to them and you tell them, look, what you have learned is a problem, it is incorrect, the person might know and realize that what they learn is incorrect, but they might still use the misconception when it comes time to make a decision. Because when you know that something you learn is wrong, you cannot just forget it and put it in the black box and forget it. That's just the simple explanation. So these are some dangers of misconception. And me and colleagues who disagree on those other issues agree, I think, about the danger of such misconceptions. But as you will see, most of those, the use of nonverbal behavior is just a misuse. All throughout history the courts see nonverbal behavior only as a way to assess credibility, when in fact, as we will see, nonverbal behavior serves many more purposes in court. And this, by the way, is highlighted in the issue of virtual trials, which we will talk about in a minute. So there is a dangers of misconceptions about nonverbal behavior. But there are other arguments against, in addition to misconception, there are other arguments against the use of nonverbal communication in courtroom, and I'll address them and I'll also give an answer to them. Well, as I've just mentioned, people hold erroneous beliefs about nonverbal cues. That's what we have just seen, and in fact, judges do use erroneous beliefs about nonverbal cues. I'm not saying they use that all the time, but there are times when misconceptions are used. So we agree, yes, but, and that's an important point. It's a very important point. People also hold erroneous beliefs about vocal and the verbal element of communication. And this should be remembered. Oh yeah, people have those beliefs about looking away and nervousness and hesitation, and the belief that it's related to lying, when in fact people telling the truth can show these same behavior. But people also have those beliefs about the vocal element. I just mentioned hesitation. That's a vocal element. So even if you were to remove a face-to-face trial and you were just going to hear the witness testifying, there's a lot of erroneous beliefs about vocal communication. There are also a lot of stereotypes depending, for example, on the tone of your voice, the speed of your voice, the fact that you hesitate, the fact that you are spontaneity, whatever that means, is often associated in court judgment to credibility, when in fact someone who's really prepared to testify can be very spontaneous, and someone telling the truth, thinking that, well, I don't have to prepare, I'm going to tell the truth, and the judge will see the truth. Well, this person could be less spontaneous, and by the way, this is another issue that is extremely important, because not only the belief of the court is that they can spot liars. I'm not saying that each of the individual judges have this belief. That's not what I'm saying. Is that the position of the Supreme Court of Canada is that judges can determine who's lying and who's telling the truth. And the public also holds this belief. Sometimes if someone thinks that, well, I'm just gonna, the judge will see the truth. That's the belief that the truth can be seen. When in fact, again, there's no nonverbal behaviors that give away the lies or the truth. So people hold erroneous beliefs about vocal elements, but also verbal elements. I mean, if someone doesn't have the vocabulary that another witness has, can it plays on the can it plays on the credibility? Can it play on the credibility? If the person explains something with words that makes it more difficult to understand compared to someone else, it will play on credibility. So really, there are erroneous beliefs in all aspects of communication. And if you were to, what I have argued in the past is that if you were to remove nonverbal behavior, you would it's just moving the problem to another direction. And not to mention, as is written in what you see, is that even if you were to remove the nonverbal behavior and you were to just keep the vocal and the verbal element, well, lawyers that when they perform cross-examination, well, they can draw witnesses into the cues, the vocal and the verbal cues, that make them appear nervous and untruthful in the eyes of the judge or the jurors. So this, if we were to limit the use of nonverbal, this would not, my position and the position of others, this would not be an argument. Because there are misconceptions in nonverbal, in verbal, and in vocal elements of communication. So another argument against the use of nonverbal communication in courtroom is the fact that nonverbal cues to detect lies are faint and unreliable. And yes, that's a fact, but vocal and verbal cues too are unreliable. And actually what's important to remember is that nonverbal behaviors to detect lies, it's really a grain of sand in the ocean of knowledge about nonverbal communication. If you say, well, let's not use nonverbal cues because to detect lies, they are faint and unreliable, it's just ignoring the fact that nonverbal communication plays so much more in the interaction than just the idea of detecting lies. Actually, if you look at the peer-reviewed publication on nonverbal communication, only a small part of that is about detecting lies. Other publications address many more issues in the impact of nonverbal behavior and nonverbal communication in face-to-face interaction. So an argument against the use of nonverbal communication in courtroom is that lie detection accuracy using nonverbal cues is slightly above chance. So therefore, we shouldn't use nonverbal in courtrooms. Well, it's a fact. Lie detection accuracy using nonverbal clue is slightly above chance. Okay, in face-to-face interaction. Yes, but this is very important, is that lie detection research is primarily conducted in context of police interviews. But police interviews are not trials. So in experimental settings, often there is this use of falsification as a way, so participant will use falsification or will tell the truth or will falsify the information. But in courtrooms, there's not always someone telling the truth and someone lying. Actually, testimonies really can be diverse and appear irreconcilable, but witness can still tell the truth, tell their side of the story for their own perspective, informed by their own premises. I can't remember if I gave this example. I know I give this example often, but I don't know if I gave it in the session of November. But if I show you this, what do you see? You see a line, but if I was going to ask you to look at the same object from a different perspective, maybe you would see this. But if I'm a third party and I hear someone saying I saw a line and the other one says I saw a rectangle, if I'm a third party, I would say someone, this is irreconcilable. Someone might be telling a lie and someone might be telling the truth. Well, in fact, both persons are telling the truth from their own perspectives. So this needs to be taken into account. And the argument against the use of nonverbal behavior in courtroom also brings another argument, is the fact that verbal cues are more diagnostic than nonverbal cue. That's also a fact. But again, lie detection research is mostly conducted in police interviews, and the interaction in trial is totally different. First of all, judges and jurors, they cannot ask open-ended questions and follow-up questions. Well, not in adversarial justice systems such as in Canada. And by the way, when a witness comes to testify, if a witness is well prepared, if the witness is represented by a lawyer and the witness is well prepared, as it is possible to do in Canada or in the United States, well, the witness will know what the questions will be. And they will even know it because sometimes there is even an obligation of disclosure of evidence. So the ways questions are asked in lie detection research, those ways that result in finding verbal cues that are better than nonverbal cues, those ways of asking questions in lie detection, they just don't apply in courtrooms. And I'll add the fact that not only the judges cannot ask open-ended question and follow-up question, but the lawyers, well, their goal during examinations and cross-examination is entirely different from the goal of police during investigative interviews. It's not a question of better goal or worse goal. That's not the point. It's just different. And if we just go on cross-examination, because if you say, well, I'm a lawyer, I will ask question to my client during, I'll examine my client, that's one thing. But when I cross-examine, well, the cross-examination, the goal, well, it's not to get information. Lawyers who cross-examine, well, they will generally ask short leading question that call for a yes or a no to get the witness to agree with them. So again, any research on lie detection that use a context of investigative interview, excellent knowledge for investigative interview. But when it comes time to bring that in a court, there are important limitations. And when those research are used to argue against the use of nonverbal and against the use of nonverbal communication and the use of verbal lie detection, well, the results cannot be applied to court because the setting is just totally different. And another argument, and the final one that I want to share with you, is the fact that training to lie detection are not helpful using nonverbal. Well, okay, I'll agree with that. But verbal lie detection training do not apply to trial context. And in a trial, is it really the goal of a judge to find who's lying and who's telling the truth? Well, there are cases where initially it might feel that someone is lying and telling the truth. And there are cases where actually someone lies and someone tells the truth. I'm not saying that everyone is honest, okay? But what I have argued in the past, and I still argue, is that before trying to, if the judge entered the room and has the idea that someone must be lying or telling the truth, that's just opening the wide door to confirmation bias. So the goal of the judge should be first to try to understand what the witnesses are trying to say. And there are trainings that improve the accuracy, for example, of emotion, intention, and personality judgment using nonverbal cues. So yes, let's forget about using nonverbal behavior to say if someone lied or not. But don't remove nonverbal behavior because it's not useful to detect who's lying or not. Because there are so many other uses of nonverbal communication in face-to-face interaction. So why I'm presenting this, the reason why I'm presenting this image is just to tell you that more than, if you go back more than 3,000 years ago, up to today, in courtrooms, nonverbal communication has been seen mostly as a way to detect who's lying and who's telling the truth. And that's just a mistake. Nonverbal communication helps you first understand each other. And if you better understand each other, then you have the possibility to better assess the credibility of someone. But if you just don't understand what the person is saying, how can you really assess the credibility of someone? Well, nonverbal behavior plays a role in understanding each other. And this is why it's so important in courts. So, and about this issue, there are thousands of publications about, this is just a graph that I've shown in the presentation of November. It was a paper that we did about the most 1,000 most cited papers on visible nonverbal behavior. It was a bibliometric analysis. But so if you look at the literature on nonverbal communication, well, first of all, yes, there is no dictionary of nonverbal cues meaning. Okay, let's get on with that. So when you see online those analyses that give behavior and that means this and a behavior that means that, that's really questionable. Because the state of research, there is no dictionary of nonverbal cues meaning. But nonverbal, let's not just stop there. That's what entertainers suggest online, that you can analyze nonverbal behavior. Well, let's forget that and look at the real use of nonverbal communication in face-to-face interaction. It displays affect, reveals attitudes, it regulates interaction, it manages impression, it reveals physical and mental condition, and it allows to exert interpersonal control. These are only a few of the function of nonverbal communication in face-to-face interaction. Only a tiny part of the functions. And by the way, nonverbal communication, well, it's much more than just the speaker's face. And it serves many purposes. It provides participant feedback to coordinate and manage in-person exchange on a moment-by-moment basis in the service of participant goal. Interacting, simultaneously act and form impression of their partner. All this, facial expression, gaze, postures, body movement, it conveys interpersonal and social information, such as the appraisal of people in the interaction, their concern and their disposition about the situations. So this is just the tip of the iceberg on the function of nonverbal communication in face-to-face interaction. And in courtrooms, in physical courtrooms, nonverbal communication, it affects the course of courts proceedings, the design, the arrangement of the courts in the courtrooms, the appearance features and the nonverbal cues and behaviors of judge, jurors, court clerks, security guard, defendant, witnesses, lawyers. These are all elements that contribute to the materialization of justice. The facial expression of people in the court, their gaze, posture, body movement. And all this can signal behavioral intention, create impressions. And this influence, it occurs much outside of conscious awareness. So let's jump to virtual trials. And that's the subject that I will end the presentation with. So because of the virtual trials happened before the pandemic, but because of the pandemic, it accelerated. And if you want to address the issue of virtual trials, nonverbal communication needs to be taken into account. So if you look at nonverbal communication or nonverbal behavior in the court, what does happen? Well, the judge can observe nonverbal behavior when they talk to witnesses and lawyers, when witnesses testify, when lawyer examine and cross-examine witness, when lawyers make their opening and closing arguments, when lawyer talks to the client, and when there is third party. Well, although appellate court, the Court of Appeal of Quebec says that the judge should focus only on the witness testifying. There are other elements that will play a role in how proceedings unfolds. And thing is that, as Miles Patterson and I have argued in the recently published paper, is the fact that in the zone trials, well, there needs to be caution about this new way of conducting trial. And why is that? Because one of the main functions of judges in bench trial and jurors in jury trial is to understand the witnesses and to ascertain the sometimes complex issues to which the law will apply. And the role of nonverbal communication is critical in courtroom, and it should be weighted appropriately before limiting in-person trials and replacing with phone and computer applications on a regular basis. One of the many issues with remote trials, virtual trials, is the fact that there is now a focus on the face. Well, it could be argued that the face is the primary channel, so to speak, that communicate information through nonverbal behavior or cues. However, it could be also argued that, well, if the focus is primarily on the face, the potential impact of facial characteristics increases. And the thing is that facial characteristics can adversely influence the evaluation of evidence and the sentence of the evidence, even when they are subject to death penalty. So facial characteristics, facial cues, this is documented. The fact that someone shows tears or don't show nothing, there is this influence on that influence the perception of judges in bench trials and jurors in jury trials. So if you focus on the face, well, the potential impact can increase. But this is really, there are other potential collateral damage to virtual justice and other consequences that were addressed by other researchers. And I'll list some of them in the next slide. So some researchers have argued that virtual justice can dehumanize defendant, that virtual justice can compromise defendant right to an effective counsel assistance. It can also hinder the image of and the role of judges. It can interfere with the symbolic function of courthouses. It can even undermine the legitimacy and the authority of the law, and even reduce access to justice for vulnerable people. Not everyone has access. Well, first of all, not everyone has a phone. Not everyone has access to internet. And not everyone has access to high-speed internet. And not everyone is comfortable using a computer. And this needs to be taken into account. There are vulnerable people who, if the trial is virtual, it will not be the same for them that if it was in person. And this should be remembered. If you are interested in the issue of virtual trial, there's this paper that was published that I mentioned before. If you don't have access to it, don't hesitate to contact me. I'll be happy to share it with you. So what I want to say in conclusion is that what I've mentioned is really just the tip of the iceberg. Nonverbal communication in courtrooms, deception in courtroom, is a subject that needs to be addressed more by researchers and practitioners. When you look at 3,000 years ago and you see how someone spotted a poisoners, someone who wanted to poison someone else, and you saw those nonverbal cues rubbing the great toe and shivering, And when you look at court judgments, sometimes in 2021, where similar nonverbal cues are used to assess credibility, well, this shows that a lot of research needs to be done. Because if sometimes credibility today is assessed similarly to what was done 3,000 years ago, this is a problem. So in conclusion, I would just say the following. Misconceptions about nonverbal cues to deception are, yes, a covered threat to the justice system, but human communication is an intricate process. And the importance of nonverbal communication during trial extends well beyond the detection of deception. It extends well beyond what is seen and what was seen in the past as the only way to use nonverbal communication. So if courts are of the opinion that nonverbal communication is only useful for credibility assessment and cross-examination, well, research on nonverbal communication shows quite clearly that nonverbal communication in face-to-face interaction serves many more purposes. And those purposes needs to be understood by researchers and also by practitioners. And given the high stakes of criminal, civil, and family trials, well, research is needed to advise legal practitioners more adequately. And on that point, I would just say the following. Most of the research on deception and nonverbal communication, when it's studied in the justice system, mostly address issues of criminal trials or criminal investigations. But there are many other types of investigations, and there are many other types of trials. Civil, family trials, I could say administrative trials. And in civil and family trials and administrative trials, there are also issues of credibility, and there are also issues of misconceptions, and there are also issues of what is nonverbal behavior useful for. So that concludes today's presentation. Thank you everyone for being here, and I wish you the best. Have a nice day. Bye-bye.